Ladies and gentlemen, good morning and welcome at our webinar from LUXHUB. We've been deciding today to address a legal topic which is linked to our main activity, APIs. The reason of this legal topic is that we have the opportunity in our day-to-day to either publish APIs ourselves and thus answer these questions, or to work with our customers that have often, of course, IT questions, but also legal related questions. We're not lawyers. I mean, we are lawyers, Amaia and myself, but we are not legal counsels. However, we thought that it might be worth to share our lessons that we have learned and also maybe to learn from you and discuss questions you might have. So that's why I invite you to raise any questions you might have, any comments that you might have in the chat, and we'll discuss this after the presentation. I'm here today with Amaia, who is a junior legal counsel, and with Claude Meurisse, with our COO. One technical aspect, this webinar is registered and the recording will be shared with you afterwards. In a few words, I will explain a bit what LUXHUB does. We are a company that is based in Luxembourg, and we provide IT services on the one hand, and on the other hand, we are a PISP-AISP, a payment institution having a specific license granted by the Luxembourg authority. And of course, we can provide also services outside of Luxembourg thanks to this European license. In this context, we have published APIs ourselves, as you will see and as will be explained by Claude. And you will. We also help our customer to publish APIs on our LUXHUB marketplace that I invite you to visit. And often questions come: what should we think about? What should we do? What should be careful about? And that's the reason why we have decided to do this webinar. What we will see today is what is an API. Well, Claude will explain in a few words what is an API, the basics. And we will look into what is an API product, because as we will mention, an API is indeed an IT element, but there are also other elements that are not purely IT that you must consider from a legal point of view. After that, Amaia will mention and address the IP rights that are linked to this API product. And I will address the personal data and contractual framework elements that should be taken into account when setting up an API product. After that, Claude will open the floor to any questions that you might raise in the chat. And we really hope that this will be helpful for you. So now I let the floor to Claude Meurisse, who will explain in a few words what is an API.
Thank you, Anne-Sophie. Welcome, everyone. It's a real pleasure to have you with us on this webinar. But before diving into the legal matters directly, we would like maybe to recall what is an API for those who are not completely familiar with the topic. So the term API stands for Application Programming Interface in a very simplified way that can be defined as a piece of software that allows a client and a server to talk to each other in order to exchange data. So you could imagine that, for instance, the weather application on your smartphone needs to update the weather information for the next 5 days. In this case, the client would be your smartphone application, and the server would be the server from your favorite national weather provider. Could be Meteorlux in Luxembourg, France Météo in France, or the IRM in Belgium. We also often call the client as the API consumer and the server as the API provider. If we take a closer look at what is happening behind the scene, in step number 1, you will see that the client initiates a request to the server. We often say that the client makes an API call to the server using an HTTP request. HTTP is just the protocol that is used to exchange this information between the client and the server. In this case, in step number 1, the client application is requesting for instance, the temperature forecast for the next 5 days. What is going to happen in the step number 2 is that the server is going to accept and receive the incoming request and is going to process it. Processing it means that it's going to receive the data and input and using this data to perform some computations and in some cases even retrieving information from a database. This computation is required in order to prepare the response that has to be sent back to the client. So that's what's going to happen in step number 3. The server will send the response back to the client. And your smartphone, in this case, will be able to display the forecasted temperature for the next 5 days. Nowadays, we live in a world where everything is interconnected. It can be computers, smartphones, IoT devices, or your cars now, watches, sensors. Most of the time, these interactions are behind the scene powered by APIs. And these APIs actually are made available by companies of any kind. We are live in the financial sector, but of course the financial companies are providing APIs, but it can be also retail stores, airline companies, utilities, or government. And more APIs are becoming an essential component of any company digital strategy. And these company APIs are now seen as real products that are advertised and monetized like any other physical product of that same company. To advertise and distribute these APIs to potential clients and consumers, companies are usually publishing the API along with the API product documentation on a specialized website, so that potential API consumers know how to interact with the API. These specialized websites can be either an API developer portal when the company operates and distributes directly itself its APIs, but a company could also choose to publish the API on a specialized API marketplace. In both cases, on these websites, the API consumer can go there to discover, access, and integrate the APIs into their applications. To be more concrete, let's now consider a real API product. We're gonna quickly browse the API product documentation of the LUXHUB One API that is published on the LUXHUB Open API marketplace. So through this API, actually, LUXHUB is offering a unified interface to access payment accounts located in different European countries. Today, we are covering access to payment accounts located in Luxembourg, Belgium, France, Germany, but also the payment accounts that are issued by the neobanks like Revolut, N26, or even PayPal. And with this API, the consumers can develop account aggregation and payment initiation services in order to integrate them into their applications. For instance, an ERP system could, for instance, integrate the LUXHUB One API to initiate invoice payments directly from the accounting application. And if you go to our marketplace and take a closer look at that API documentation, you will discover some elements and components that have some legal implications. And when you have to build your own API product, you will have to pay attention to these elements. What are these elements? If you look here on the slides, you will see that as any commercial product, your API is going to have a logo that might be protected. Your API will also have a name, the API product name itself. When the API is published on a marketplace, the company that is publishing its API is also something that you have to consider from a legal perspective. The URL that is used to access the API endpoint is also protected because there is a domain name behind. Also, when we talk about API product documentation, you have to consider the commercial and the technical documentation. Apart from that, there is also the OpenAPI specification itself, previously known as a Swagger documentation. So it's a standard way to represent an API with the different resources, access points, and data fields exchanged between the API consumer and the API provider. And if you go deeper into the API and the data fields, you, for some APIs, may also have to handle personal data information. In case of payments, you have personal data. So all these elements, because of the potential legal implications that they may trigger, have to be carefully considered when developing and building your own API product. So now I will leave the stage to Amaia, who is going to explain you further what these implications are in terms of intellectual property rights. Amaia, the stage is yours.
Thank you very much, Claude. Yes, as you mentioned already, there are some implications that we have to take into consideration related to intellectual property. So I will talk a bit about trademarks, domain names, trade names, rewriting, and corporate names. In essence, you have an API product, and you may have also a logo or a sign that you want to register. And there are some laws that you have to take into account. Basically, when you have a logo, you will have to consider whether this logo is already registered by another competitor. You will have to verify this because there are fines, very potential high fines that you may bear in case you infringe the intellectual property rights of others. So when you have your API product, you have to think about this. You also may want to register your API product under a domain name, as Claude already mentioned. So you have to verify that there is not another one already used by another competitor. And you also may want to register your corporate name, and you will have to verify again that is not similar to an existing one. And it's only a recommendation that we tell you to do, and we always advise you to check with a lawyer. We know that maybe if you are a small company, you may not have the resources to do so, but it is important because this will change potentially your idea of the product name that you want to choose. You have to think about all these things before, and always consider the risk that it exists of having a name or another. You may have started using this name already, and it's only after a period of time that you actually consider the idea of registering it. And this is also important because actually there is potentially another person that is already using this name, and you will even eventually have to potentially prove that you have been already using this name for a long time, and you are actually protected under the law. As you can see in the slide, I have put there the concept of free riding and covered under Luxembourgish law, and essentially this concept could be used by you in the court if you want to challenge a competitor that has started to use a name after you have been using it for a long time, because even if you have not registered it under trademark law, you can potentially argue that it is already part of your business, and the public knows that this name belongs to you. And I included here in this slide some useful tools that we advise you to use, and they are free for you. So if you don't have the resources to pay for a lawyer for legal advice, you can always check yourself if your mark, the potential mark that you want to register is already used by another competitor, or if the domain name that you want to register is already used by another entity. And also, before you register your corporate name, you can always check in the Luxembourg business register whether this is already used by another one. And here I'm going to talk about other intellectual property rights, but this is a bit controversial actually, because we at the moment we don't have a clear answer on whether there is copyright and for APIs or not. This is a question that is being taken by the courts in the US and in the EU, and they both disagree on whether APIs are protected or not. In essence, copyright is an intellectual property right that is automatically granted for APIs. It's automatically granted for works that are made by an author. So for works that are expressed, for expressions that are so for intellectual works that are made by authors, and computer programs, including the prepared design material in any form, are protected by copyright as literary works. Ideas and principles which underlie any element of a computer program, including those which underlie its interfaces, are, however, not protected by copyright. So, in essence, it's not very clear under the law whether APIs are protected or not. But it could be argued that since they are the intellectual work of someone, they are the creation of someone, they are protected under the law. So for this reason, we have seen cases that have been taken by the court for over the years, and the matter is still not settled. In the slide, we have included SAS Institute against World Programming Limited. And this case is very interesting, proving this point, because on the same facts, it's been decided differently by the courts in the EU and in the US. In essence, in the EU, the courts tend to favor interoperability. So they tend to favor developers by not granting copyright to APIs. In this case, SAS Institute brought the case against the court in the UK. It started in the UK because under the contract, the governing law was the UK law, and it was a matter to be decided in England. So that's why the courts of England started taking the case. However, it was finally decided 17 years after in the US because the SAS actually was arguing that that World Programming Limited had infringed the license they have with them, and this license was subject to US law. So that's why the court, even though the whole contract they had had a clause in which it was established that English courts had to take the case, the license was subject to US law, and that's why it was decided. This is very important also to have in mind, because when you have a contract, the clause that deals with the who will take jurisdiction, it's very important in terms of copyright, because the actual damages that Walt Programming Limited had to pay at the end was $79 billion. And in the UK, at first it was decided that Walt Programming Limited was not infringing the copyright of SAS. However, 17 years after, the Supreme Court in the US decided otherwise, and Walt Programming Limited had to pay SAS $79 billion for infringing their copyright. So as you can see, the US is taking this very copyright point of view about protection of copyright, whereas in the EU, in essence, as of today, we don't have protection of APIs. In a second case, which was decided only last year, the Supreme Court again decided that APIs are protected under copyright. However, this is the case that you can see on the slide, Google against Oracle. And in this case, it was decided that Google was not infringing the copyright of Oracle, who was arguing that they had infringed their license because they had infringed their license. But the Supreme Court, after other courts, district courts decided that there was actually copyright protection. The Supreme Court decided that Google was not infringing this copyright because it was falling under the fair use exception. The fair use exception is well known by lawyers, but I'm going to explain a bit why it was decided like this. The US, at the end, they concluded that Google used only what was necessary to allow programmers to put their talents to work in creating new and transformative works. So actually the US court last year decided to favor innovation more towards the tendency in the EU, and decided that Google was actually not infringing the copyright of Oracle, even though by saying that it fell under the fair use exception, that means that they actually believe that there is copyright, otherwise it could not follow under the fair use exception. And to end, a final point, in case you were considering to register your API as under patent law, this is not possible in itself because, as you can see in the slide, the European Patent Convention under Article 52 says that programs for computers shall not be regarded as inventions. This is explicit in the law, and you cannot actually register. You can actually apply for a patent of your API, but if it's a part of a bigger thing, it could potentially be considered as an invention. I now give the floor to Anne-Sophie, who will be talking about some personal data issues and contractual aspects that you may consider when.
Yeah, exactly. Thank you very much, Amaia. So quite a lot of IP aspects to consider when you're setting up an API, for sure. But of course, what is transiting via an API is most of the time data. Sometimes personal, sometimes non-personal. If I take the slide that Claude was explaining at the beginning, a lot of personal data. If we look at LUXHUB, one in which we might have payment initiation or account information data, well, you might have the name, surname of the person. You might have account-related data. So quite a lot of personal data. And also you might have amounts which are not necessarily personal data. So quite a lot of aspects to consider because, of course, personal data raise often a lot of questions and a lot of people directly here GDPR, which is a very good reflex now. So we will start with the personal data. The French Data Protection Authority is actually currently looking into setting up a technical recommendation for APIs, what to consider from a data protection perspective when you set up an API. And that's very interesting. If you are keen to read it, so unfortunately, to my knowledge, it's only in French. But what is interesting is that you can answer to this consultation that is open until the 1st of November. So you should read it if you can read French or have a translator, and eventually address your comments. What I find interesting, particularly in this technical recommendation, is the different qualification that the French Data Protection Authority is bringing and how they consider each actor. So they've been defining three main actors in the API economy, if I may say. We have, of course, the data holder. We're going to have the data reuser, the one that is usually calling the API to retrieve the data. And we have the API administrator. That's how they qualify the different stakeholders in this scheme. Who is what? Then that is the question. Well, the data holder is usually the data controller because it is the one that is already holding the personal data. So it has the contact with the data subject and it has already a processing that is existing. Then this data holder, and I will take a parallel with what we do with PSD2. So, you know, this directive payment services. The main service, well, the service for which LUXHUB has been incorporated originally, it was to help banks to open up their data in the context of PSD2. So if I take a PSD2 API, the data holder is the bank. Then the processing, the bank is processing the data. In order to open up and ease a bit the process and have their API published, these banks have had recourse to what is called an API administrator by the CSSF, by LUXHUB in this context, where we help the financial institution to publish its API and have contacts with the third parties that want to consume this API. Usually this API administrator, and it is the case in our PSD2 scenario, the API administrator is considered as a data processor. What does it mean concretely? It means concretely that there is a data processing agreement between the data holder and the API administrator. And the API administrator must abide by different rules set up, laid down by GDPR. But one of the very important point, of course, is the security. Must ensure to have strong security measures and that these measures have been agreed upon between data holder and API administrator. And of course, we have the data reuser, the one that is consuming this data. Well, the French Data Protection Authority tells us, well, usually we consider them as recipient. Sometimes it happens that they are co-controller. For instance, you can have a data holder and a data reuser that decide, okay, we want to have a new marketing campaign together, and we want to do something. So we have one purpose that is the same for both. Then we might imagine that we have co-controllership. But most of the time, actually, the data reuser is a new data controller having a complete new processing, meaning that most of the time there might be a contract between data holder and data reuser, but there will not be as such a data processing agreement. But that's one important thing to think. If you're a data holder, you publish an API. If this is containing personal data, then ask yourself, what is my role? Because I explained you the role, for instance, of PSD2. but there are various cases. So always ask yourself, what is my role? Because this can always change from a case to another. And if I am a controller, then I need to think about, okay, I need to have a data processing agreement. I will need to check that the one that is processing the data in my name on my behalf is not doing something wrong, that the security measures are sufficient. I must also, and that's one of the things that the French Data Protection Authority is pointing out, and that is not always so easy on the chain, is really to ensure full transparency towards the data subjects. It is not easy because there might be changes in the processing, and that's sometimes difficult to recontact the persons, but that is one of the key principles of GDPR, and that should not be forgotten. So always think, I have an API. Do I have personal data? If I have personal data, have a look at the technical recommendation of the French Data Protection Authority. It might change in the meantime. I don't exclude because it's under a consultation, but that's interesting. And always think, okay, I need a DPA. If I send data to a third party, what is the third party going to do? Am I co-controller or not? If I'm not co-controller, well, then the recipient will have its own obligation, but I have to ensure that the one to whom I send the data is not doing something completely wrong with it, of course. So that's on the side of the personal data. But of course, there are also data that are not only personal, that are potentially also personal, but not only. If you set up an API, usually behind it you have a database from which you retrieve the data you will put at the disposal of the one calling the API. Well, then you need to ask yourself the question in your organization, I have a database, is it protected? Is it protected in a way or another? Can I extract whatever data from it? That's linked, of course, to the previous point. You need always to think about what are the data I put at the disposal of third parties via this API. Is it a protected data, yes or no? And am I actually allowed to retrieve it? If I retrieve actually absolutely all the data from the database and I put it via an API, I have to check with the one that has been setting up the database that I am actually allowed to do so. So internally, and actually that's one of the things that we notice ourselves when we set up an API, a lot of questions we need to ask ourselves internally. Of course, there are IP points that we need to check externally, but internally you need to discuss and make sure you're actually allowed to put this data at the disposal of third parties via an API. And that's the same for trade secrets. If the data you have in your database or not are and covered by, considered by your company as a trade secret, well, of course, you will not put it in principle in a completely public API and not even in API. You have to think about the sensitivity of the data you put at the disposal of a third party. All what I said is extremely logical, but sometimes we have access internally to files where we don't necessarily think that they are so sensitive or that they are so important because we have the habit of having access to this information. But never forget that there might be specific rules applying to it. That's for the data part. And the last part, which is also extremely important and which raises quite a lot of questions, because I have had already quite a lot of discussions about this, is the right contractual framework, or actually the contractual framework. As you can see on this, LUXHUB 1, so the API that was presented by Claude earlier, is an API that cannot be accessed by everyone. It's an API that is subject to the execution of an agreement with LUXHUB before accessing to it. There are different kinds of APIs. You have public APIs, you have partner and private APIs. When you have a private API, well, usually it's internally. People have already signed a non-disclosure agreement internally, or they are under a specific rule. So usually you don't need a contract as such, except a confidentiality clause with your employees. But then when you have an API that is partner or public, you have your API that is consumed by third parties. And then you need to ask yourself, what kind of contracts should I have in place? Most of the time, if you have a public API, you use terms of services that are standard. There's no negotiation, because if your API is free, which is often the case with public APIs, well, you don't have to negotiate much, apart from the fact that you need to protect yourself. And but even if the people pay for your API, you don't want to negotiate. If you have a mass API for very large consumer base, you don't want to negotiate every single term. So you have usually terms of services. You might also have terms of services with a partner, but usually with a partner API, you will really have selection process most of the time of this consumer. So yeah, it might happen that there is a bit more negotiation. Some things that should not be forgotten in relation to contracts and APIs. What I hear very often is, we have no contract. We have only accepted the terms and conditions. Yeah, but the terms and conditions are a contract. So it's important that in your organization, and now I address the biggest pain point that all companies have, that your developer, when he goes on the developer portal and he accepts the terms and conditions, must ask itself, am I entitled to do this? And of course, if it's only accessing a dev portal and accepting terms and conditions, you see what is in the terms and conditions, but usually it's targeted at developers. But to consume an API, it is another thing, because if there is a payment, for instance, your developer might not always be entitled to sign a contract for a financial obligation. So when you set up the contractual framework around your API, you have to be careful on the signature process, on the acceptance process, how the person is really accepting the terms and conditions, and how you make sure that this person that is accepting the terms and conditions is entitled to do so. I have no magic answer to this, unfortunately, apart from drafting a specific wording, and that's what we've been doing, specific wording saying, well, if you accept the terms and conditions, you confirm us that you are entitled to do so. That's one way to make sure that the person you have in front of you is really the one entitled to accept them. One other point that comes very often is the readability, because reading terms and conditions is one of our passion with Amaia, but it's not the passion of everyone. And it's important, particularly when you want to make sure that developers are really are following what is written on your terms and conditions. You need to make it readable, and you need to make it accessible. Why not putting in your API documentation some rules that recall what is in your terms and conditions? Why not putting some pictograms? Why not having a way to make it more accessible? This is something that I say and that we try to work on. It's not an easy task, but we're not the only one. Actually, you can see on the screen an initiative about API terms of services. That is an initiative that has been put in place to try make it better, to have readable and understandable terms of services. So I invite you to have a look at this. We've been, Amaia and myself, participating to one of their meetings, only one for now, but this is an initiative that I find personally very interesting, and I'm pretty sure that several of you have also the challenge. Of course, what we should have in your API contract, it's like a standard contract, object, the description of the API, what are the parties' obligations, and from this, you should actually take some of the points that you put in your API documentation as a recall of the obligations that are in the terms and conditions. Force majeure event, limitation or exclusion of liability on certain points. It's particularly important. If you put a public API for free, you don't want to have your liability in the game because you forgot actually to have an exclusion or at least limitation of liability. That would be a pity, because as such, usually you do a public API for free for visibility or for good to help third parties. So that would be a pity that you have your liability involved for this. Important point, Amaia mentioned it, IP rights and governing law. Very important, because depending on the jurisdiction and the applicable law particularly, rather than the jurisdiction actually, will depend whether or not you have copyright on your API. Whether or not people can make publicity, that you maybe see it sometimes that people say, well, I am powered by Google, but sometimes you ask yourself, does the person really have the right to use the word powered by Google, or it's just because the person has been using an API from Google? Ask yourself the question, do you want that any API consumer use your logo and say, well, we are powered by my company? An interesting point to put in your terms and conditions. Of course, the fees, if there are some. Eventually confidentiality, because we mentioned we might have personal data, we might have trade secrets, so we don't know. We want to have eventually confidentiality. And very important point, last point, if using the API might be considered in a way or another as an outsourcing, ask yourself the question, does it qualify as an outsourcing arrangement? So in Luxembourg, we have the latest CSSF circular 22806, but in Europe, you have the EBA guidelines on this. Always ask yourself the question, does it qualify or not as an outsourcing? I think I have been going through more or less the key takeaways on the contractual part, and I will let Claude finish. And I forgot actually to ask you if you have other questions. I am not sure whether we have received any questions in the chat for now. If you have, don't hesitate. And I will now let the floor to Claude to finish.
Thank you, Anne-Sophie, Amaia. I don't see any questions so far. You still have some time if you want to drop one on the chat. Well, I guess that the presentation was crystal clear. Thank you, Anne-Sophie. Thank you, Amaia, for the presentation. As Anne-Sophie mentioned, the webinar was recorded, so you will get access to the webinar right after the session. I hope you enjoyed the session, and we count on you to visit our marketplaces, and we would be ready to help you in the future if you want to publish APIs with us. Thank you very much, everyone, and hope to see you for another webinar in the future.